The response of the judiciary, it was, according to me, it was equally disappointing. Though the Act clearly applies to courts which are obviously included in the definition of public authorities, most high courts did not appoint even the public information officers, within the prescribed time. And many of them who appointed PIOs, framed rules which effectively deny the information to the citizens. I will give one sample of the Delhi High Court rule. The following information shall not be disclosed. Such information which is not in the public domain or does not relate to judicial functions and duties of the court and matters incidental and ancillary thereto. The rule means that no information will be given about the expenditure incurred by the High Court from public funds and about any appointments or transfers or about any recruitment. This was a totally violation of RTI Act, where the disclosure can be withheld only on certain grounds specified in Section 8. No public authority can refuse to disclose information which does not fall under the exemptions permissible under Section 8 of the Act. It is reported, I am quoting the newspapers, that the former CJI recommended to the government that so far as the Supreme Court is concerned, the decision of the Registrar General of the Court should be final and not subject to any independent appeal to the Central Information Commission. It was reportedly recommended that the Chief Justice of India should have the unfettered right to interdict the disclosure of any information, which is, in his opinion, might compromise the independence of the judiciary. The former CJI had gone on record that even the disclosure of income and assets by judges or the formation of any independent disciplinary authority over judges would compromise the independence of the judiciary. Now, as Mr. Gonsalves told you, this issue is now referred to the larger bench yesterday, and I read in the newspapers that 19 high courts have responded that they would not prefer to be covered by the Right to Information Act. I don't have the exact response of the High Court, but it seems that this was in the context of the information relating to the elevations and transfers of the judges. Anyway, this is going by this, it is obvious that no information about the complaints against judges, about their incomes and assets would be available under the Right to Information Act. Thus, while the Supreme Court decrees that even candidates aspiring to become public servants like MLAs and MPs would be required to disclose their assets, when it comes to sitting judges, such disclosure would violate the independence of the judiciary. I may refer to today's reporting about the observations of Justice Karchu about the Allahabad High Court. And I do not wish to make any comment on but time has come that the judiciary has to be, the functioning of the judiciary has to be made more transparent. And it's not the issue of the compromising the judicial independence. In Subhash Chandra Agarwal's case, he said that the transparency would lead to more accountability, and ultimately it would enhance the image of the judiciary, and really the transparency and they should go hand in hand, the transparency and judicial accountability on the one hand and the judicial independence on the other. Now, in this context, I may also refer to Subhash Chandra Agarwal's case. Now, there the question was, Mr. Subhash Chandra Agarwal's query was whether the judges of the Supreme Court have furnished the information about their assets to the CJI. There was a resolution passed by the Chief Justice's Conference in 1997 that all the judges of the Supreme Court and the High Courts will furnish information about their own assets, about the assets of their spouses and the dependent members. And the only query was whether such information was furnished. The stand taken by the registry of the Supreme Court was that the CJI doesn't fall within the purview of the RTI Act. finally this particular defense was given up, and several contentions were raised. Some of these, amongst other arguments, it was contended that the information sought related to subject matter which was an in-house exercise and thus could not be said to be held under the Act. It was also argued that the Code of Ethics formulated by Chief Justice's conference, pursuant to which the asset information was published and moved binding force. These are all code of ethics or judicial conduct, standards of judicial conduct, which were laid down in the Chief Justice's conference, and every judge is expected to follow this. But the stand taken was that it has only a moral force, it has no binding force. And ultimately this has led to the judicial standards and the accountability bill 10,000. That is likely to be introduced in this winter session, where this judicial standards or judicial code of ethics is made a part of the statute. So the argument was CPIO was rejected, and it was held that there was a right to such information. The information emanated from an instrument which had not just moral force but had legal value. More importantly, the information requested under the application was not of such a nature which would compromise judicial independence. Now, pending these proceedings, the Supreme Court judges already published declare their assets on the website, Supreme Court website, and some of the high courts followed suit. The Delhi High Court and two other high courts published their judges' assets on the website. Now, I really don't know why should the independence of a judge be affected if his or her wealth is made public under the RTI Act. And what Mr. Farinariman said, I just would like to quote his words.